Next, former Solicitor General Walter Dellinger leads a discussion with constitutional law experts on presidential power and whether the president has to follow the law. Southern Methodist University Law School hosted the discussion on November 18th in Dallas. Other panelists include Stanford University law professor Kathleen Sullivan, former Solicitor General Kenneth Starr, and Berkeley law professor and author of the Bush administration torture memos, John Yoo. This is a little less than 2 hours.
We'll kick off with our first panel, Executive Power. Does the President have to obey and follow the law? My panel members and I will go from my right and your left, I guess. We have, it's Kathleen Sullivan, Chair and partner of Quinn Emanuel. Next, we have David Cole, Professor at Georgetown University. Walter Dellinger, who is our moderator, is seated in the center, and he is appellate chair and partner in O'Melveny and Myers. Then we have Professor John Yoo from Berkeley, Bolt Hall. What do we call it? Something else now, I guess.
Berkeley Law.
Berkeley Law. And last, Judge Ken Starr, president of Baylor University. Now, rather than, I know that somewhere in your materials you have the resumes of all of these individuals. This is truly an all-star panel. It is a true privilege for me to be able to introduce them. But I could take the entire time that our panel has to tell you about everything that all of these individuals have done. So rather than do that, I'm going to tell you a little bit about what we are as a group and what the panel is as a group. Of our group, we have 5 law professors. We have 3 that have been deans of law schools. We have 4 that have been appellate clerks, circuit clerks, 3 that have been Supreme Court clerks. We have of oral arguments in front of the combined in front of the U.S. Supreme Court, 70 oral arguments in front of the U.S. Supreme Court, amazing, and hundreds of arguments before the intermediate courts of appeal throughout the country. We have 2 Solicitor Generals. We have 2 members that have been head of OLC and deputy Office of Legal Counsel for the President. We have 1 circuit judge. We have independent counsel, and we have members of our panel that have worked with presidents, starting with President Reagan through Clinton, Bush 1, Bush 2. We don't have anyone on the Obama administration at this point, but they probably wouldn't be able to talk about what we want to talk about now if they were presently serving. So, but we're going to, so we can talk about it. And perhaps we have authors. All of them have written a great many pieces, but probably 2 of particular relevance are, we have John Yoo, who's written most recently on Crisis and Command, and we have David Cole, who wrote on the torture memos, and he said that John Yoo co-authored that with him, but I'm not sure that he did. But anyway, it was he was a silent partner as an author. And probably last but not least, we have an actual president we have President Judge Ken Starr. So with that all in mind, we will get started on the topic. I will let you know that we will leave time at the end for questions and answers. And if you notice in the room, we've got a mic to my left and to my right. And so when Walter Dellinger indicates that it's time for the Q&As, please line up at either side and we'll welcome your questions. So without further ado, Walter, I turn it over to you.
Good afternoon. In addressing a group of distinguished federal and state judges and those who appear before them as advocates, it may seem strange that we're talking about constitutional interpretation, not by judges, but by the president and those in his executive branch. We've become so familiar in our legal culture with thinking that interpreting the Constitution is the province of judges, that it often comes as a surprise to confront the degree to which the president is a constitutional interpreter and decision maker. This might not have been the case if the Constitutional Convention had not made a dramatic change in the nature of the presidency in the final 11 days of that remarkable event that took place in Philadelphia between May 17th, lasted throughout the summer until September 25th, 1787. The Constitution, in its next to final draft, as the convention took its one recess of the summer, its next to final draft of August the 6th, provided that the president was just to be a manager for Congress. The president was to be chosen by Congress and was removable by Congress for maladministration or neglect of duty. The Congress chose not only the president but the treasurer. The Congress had the power to make war, not simply declare it. The Senate had the exclusive authority to enter into treaties, and the Senate had the power, with no participation by the president, to appoint all judges and ambassadors. That was the Constitution in its next to final draft as they returned September the 4th with 11 days to go. And yet we know something very dramatic happened at the end. A method of choosing the president which the framers knew would be popular input. They assumed that electors would be popularly chosen in some fashion. They were soon elected, and that they would reflect the wishes of the general public. Those who favored direct election of the president by the people, but knew the practical difficulties, so this was the next best thing. This was the immediate, not immediate, but one step removed, selection by the people. So that gave the president an independent basis. They then toughened up the removal standard, so he no longer served at the virtual pleasure of Congress to make it treason, bribery, high crimes, and misdemeanors. Gave the president a role in negotiating treaties and in nominating judges and nominating ambassadors. All very dramatic. What happened to cause this dramatic change? What happened was, I think, over the course of the summer, the nationalist vision triumphed at Philadelphia. And the national government was given extraordinary authority over all of the western lands, over what John Marshall was to call all of the external commerce and a not inconsiderable portion of the domestic commerce of the nation, the power to tax, the power to operate directly on individuals. It was an awesome amount of power to confer upon a national government continental in scope, going way beyond anything anyone had imagined, except perhaps Madison sitting alone in his study in the winter of 1785, going beyond what anybody could have imagined would be proposed by this convention. Having given it power, they realized that it needed executive leadership. And that's why the president was created not so much as a manager, as had been foreseen in the early days of the convention when Roger Sherman said, Congress can decide from time to time how many people should make up the executive and for how long they should serve. There's no need to even specify that in the Constitution. From that view of whatever Congress wants, one person 3, 1 year, 3 years, 6 months, that's what Roger Sherman thought, which was not far off at the beginning of the convention. By the end, they wanted a strong and independent branch of government. And that has given us a president that is his own constitutional officer, not an employee, not a staffer. And that has led presidents to take the position that they could make and were obligated to make their own determination about acts of Congress. So, just to introduce the scope of our discussion, obviously every president has to interpret the Constitution. Where Congress has not acted at all, the president would have to decide to what extent he could engage in warrantless surveillance and seek his own counsel on that. A president, in the absence of a code of uniform military justice, would have to make his own decision about how to discipline the troops and what the constitutional requirements would be. The more harder questions, the one we'll be addressing, are those where Congress has said what the limits of the president's authority are. And when can the president assert that those are unconstitutional? Virtually every president, as far as I know, at least every modern president, has taken the position that the president can decline to obey some laws. And that has been unremarkable in the sense that the Supreme Court in 1926 in Myers versus the United States thought it unremarkable that the president ignored an act of Congress and deliberately discharged a postmaster without the consent of the Senate as required by Congress. And the president declined to defend that law in the Supreme Court. Counsel for the Senate came forward to do so. And the Supreme Court thought it unremarkable that the president had not done so. More recently, there's been a debate about the degree to which the president should show deference to Congress, even though he ultimately has to make his own decision. And whether, particularly in fighting the war on terror, the president declined to comply with acts of Congress that were in fact constitutional while claiming they were unconstitutional. We'll hear a debate on that as time goes on. So that's the matrix of issues. There's one more recent one. When is the president authorized to tell his attorney general to tell the Supreme Court that it ought to strike down an act of Congress? Like, for example, don't ask, don't tell, that the president is complying with but has said he believes to be unconstitutional. What can you tell the court about your position? What is the duty to defend? It's a big menu of issues about the president's constitutional decision maker, and we will therefore fittingly start with a president, President Starr of Baylor.
Well, and thank you, Walter, and thank you all. So good to see so many friends from bench and bar. Let me begin with the text. I'll come to the oath of office. But Article 2, Section 3 enumerates in brief compass the powers of the president. And one of those critical powers is he shall take care that the laws be faithfully executed. The oath of office set forth in Article 2, Section 1, and here is the oath. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Taking those two together, as well as the fundamental bedrock concept that ours is a system of laws and not of persons, the will of the people as manifested in law, what Cardozo called the authentic forms of justice, which express themselves in law, not in philosophy, not in ideology, but what is in fact the law. Wilson, as in Woodrow Wilson, as an academic at Princeton, as the first occupant in that Naughton Law School University of the McCormick Chair of Jurisprudence, wrote that the president is accountable to Darwin, not to Newton. Government is modified by its environment, necessitated by its tasks, shaped to its functions by the sheer pressures of life. And so when the question is posed, must the president obey the law, the intuitive answer of those who lift up the values of the rule of law is yes, of course. But maybe there are exceptions, because I sort of remember reading about Abraham Lincoln and the Lincoln presidency. Perhaps at another occasion there was room for debate about Lincoln's fidelity to constitutional norms. But the Lincoln presidency, and to a certain extent the presidency of all those presidents called to serve during what turned out to be a time of war, raises, in my mind, the most critically clear dimension, which is intentional, willful disobedience by the president to a clear norm. I know what the law is, and I'm simply not going to obey it. And it seems to me that a way of looking about that, and you will probably have a debate with respect to that more currently, but just think of Lincoln, perhaps think of Wilson, think of others who have perhaps, quote, taken the law into their own hands. I think a way of thinking about it is to draw from sort of analogous pools of law. The Fourth Amendment sets forth a very powerful norm of protection of privacy, of human dignity, interests. And yet we know through the case law that there are exigent circumstances to getting a warrant, having probable cause. So there's sort of an exigent circumstances exception, perhaps. the presidency, the president and his advisors. Another is, and I think this is seen in the Lincoln presidency, and Professor Yu and others can speak more knowledgeably about the history of presidential obedience or lack thereof to law, is really from corporate law. The idea that management will take actions that may in fact be viewed as ultra vires under a strict interpretation of their powers, perhaps intrude into the arena of the board of directors, but then seek ratification. That certainly was a Jeffersonian idea, and one might say it was Lincoln's idea as well. Another value that's a more modern value is that drawn from the bucket of securities law, of disclosure, of transparency, of illumination, of the Brandeisian type of value. This is the great disinfectant. And so it seems to me that a way of thinking about it in the worst situation, willful disobedience of a cognizable, identifiable norm, is democratic accountability, and perhaps exigent circumstances coupled with doctrines of ratification and disclosure, transparency, help us to understand that and to look back on a Lincoln presidency and not come to the conclusion that he really was a dictator, as some have said. The second point is where there is, and this is, I think, the sort of insidious question, where there is an undermining, perhaps even knowledgeable, intentional undermining of existing constitutional and legal norms, but without a clear, undisputed, just cold on the docks violation. And I think historians might very well identify President Wilson's conduct during World War I, especially with respect to civil liberties. Very controversially, obviously, and infamously, really, is President Roosevelt's internment of the Japanese Americans during World War II. And that brings me to and I realize Karamatsu and the other cases upheld that after the fact, but decisions that have largely, if not completely, been discredited. Which brings me to my third and final point, which is, in the midst of all this, what should be the role of those of us who have been privileged to serve and our predecessors and successors in the Justice Department. And what I would like to lift up for conversation and reflection is the fact that at its best, the Justice Department will really be the conscience of the presidency. The Justice Department will be filled with great lawyers who will be holding up yellow cautionary signs. They will be flashing red lights. We saw this stop signs, and we saw that in connection with the internment of the Japanese American community. Because one of the great heroes of that losing battle was Francis Biddle, the Attorney General. And in his memoirs, but it's confirmed by others, he fought very valiantly, but remaining within the administration, he did not resign, saying this really cannot be, this should not be in a free society. The predicate, the grounds simply are not there for this. And it seems to me that that is one arena that to serve those rule of law values, that the role of the Attorney General himself or herself, and then those who are called upon to serve in the Justice Department, is extremely high in terms of the values of the conscience of the presidency and fidelity to the rule of law. A quick war story, very now uncontroversially, but when Congress time and again came forward with a device called the legislative veto, that we, a single house or even a single committee, can overrule a legislative veto. This was, by the way, a pro-good government reform introduced by the Hoover Commission on the Reorganization of Government and ordained by President Roosevelt. As government is growing, how do we get control of the growing bureaucracy, et cetera? And one arena that was suggested, or one device, was the legislative veto. Then candidate Ronald Reagan had in the platform, it was in the Republican platform, and he actually referred to it in a couple of speeches in terms of getting control of the bureaucracy, was the legislative veto device. But once he took office and advised by the Office of Legal Counsel, Ted Olson, advised by the Attorney General of the United States, William French Smith, Bill Smith, both of whom I was privileged to serve, the President of the United States just did a mea culpa and repented of his position, much to the chagrin, I should hasten to add, of the domestic policy folks in the White House who felt this was a very important device. So why did the president change his view with respect to the legislative veto? Because the Justice Department told him it was unconstitutional. And that, to me, is one of the great roles for the Justice Department to play in assuring, as best we can in an imperfect world, presidential fidelity to law.
You've got some people on this panel, Kathleen, who celebrate the president's fidelity to his oath to uphold the Constitution and his decision to subordinate the obligation to take care that the laws be enforced to the superior obligation of constitutional over statutory law. I think from time to time you've expressed some concern that those in the executive branch have gone too far in asserting the president's authority to do this. How can you defend such an ill-considered view?
Well, I haven't worked in the Justice Department, and I think that to work in the executive branch has, no doubt, has steered the experience of my very esteemed fellow panel members toward seeing the need for presidential action, and maybe it's a perspective one takes when you're in the moment of crisis. But what I'd like to do is refocus us perhaps to the theme of this conference, which is the role of the courts. And the point I'd like to make is that in a time of emergency like the one we've witnessed over the last decade since the terrible events of 9/11, when you ask the question, well, does the president need to take emergency steps? Does the president need to act without prior clear authorization by law or treaty to protect the homeland? Does the president have to act with zeal and dispatch and to invoke predecessors from Jefferson to Lincoln to Roosevelt as the source of authority? Should the court step in and prevent the president from doing so? And I'm going to argue that the courts have played a very important role in restraining excessive executive exercises of discretion during this period. And the other body that might have stepped in is, of course, the Congress. And I want to talk a little bit about what the framers intended the role of Congress to be, how Congress really can't play that role today, and why it is all the more important that the judiciary, the independent judiciary, play a role of restraint on the executive branch. So just to go back to the executive branch for a minute, we don't have any emergency powers in the Constitution. Unlike the Constitution of most other industrial democracies and new democracies, there's no exception clause. There is no exigent circumstance clause in our Constitution. And therefore, when the president acts extra-constitutionally because of emergency or national security crisis, he's doing so on his own initiative without a particular constitutional warrant for that. Now, of course, the Fourth Amendment doesn't have an exigent circumstances clause either. But not only is the president doing that without constitutional warrant, he's doing so in the modern era in most cases with also very extravagant claims of secrecy in his power to do so. The invocation of state secret privilege in every case says we can't even find out what the reasoning is behind why you invoked the invisible exigent circumstances clause. Now, the president will not be self-restrained. This is not a matter of one party or the other party. Presidents of both parties and both sides throughout our history, as party definitions have changed, presidents always want to maximize the power of the president to protect the interests of the country as he conceives it. And this is why you see members of the Clinton administration and the Obama administration writing memos supporting powerful executive authority, just as much as members of the Reagan and Bush and W. Bush administrations. The president, to go back to Francis Biddle, Ken Starr just told you a moment ago that Francis Biddle counseled against the Japanese internment. Well, he lost, and in that same memoir, he said about Roosevelt, about FDR, I don't think the constitutional difficulty greatly troubled him. I don't think the constitutional difficulty has ever troubled a wartime president. That's the rest of Biddle's memoir on that point. I think that's exactly right. And Truman was quite unrepentant later about the steel seizure. You all remember that the court struck down Truman's seizure of the steel mills to avert a stoppage during the war in Korea, the undeclared war in Korea, a stoppage of production of steel that was necessary to munitions and armaments going to the troops in battle. Well, the Supreme Court struck down that act, saying it exceeded executive authority, it lacked legislative authority, and They did so at a time when his approval ratings were hovering around 22%. It may have been perceived that the court can stand up to a president who isn't that powerful. When the court finally smacked Lincoln for unilaterally suspending the writ of habeas corpus during the Civil War, it didn't do so until after the war had ended. So the court may stand up to the president only at a time when he's perceived as weak. But Truman was apparently unrepentant about the steel seizure. As stoppage was averted, no consequences resulted that harmed the nation, but he didn't think the court was right. The story is told that he went to a dinner party at Justice Black's house soon after the decision. Black had written one of the principal opinions for the court invalidating the steel seizure, and it said that the conversation was a little stiff, but that at the end of the evening after libations had flowed, apparently Truman said to Black, "Well, sir, your law's no good, but your bourbon is." But I bring these anecdotes to bear just to suggest that if Roosevelt felt unconstrained and Truman was unrepentant, it will rarely be the case that the president thinks that his action in excess of executive or legislative authority, even when struck down by the Supreme Court, was the wrong decision at the time. So then you might say, well, what about the Congress? Well, I'd like to suggest that the framers, notwithstanding Walter's account at the outset of the dramatic shift toward greater presidential power at the end, it's true, they went from a kind of pure agent-manager vision to a vision of executive leadership and a fully separated set of branches of co-equal status. But the single most important principle of the framing with respect to separation of powers was that legislation must constrain discretion, that Congress must constrain the president, that the president, notwithstanding that he has the power to take care that the laws be faithfully executed, that is a power of agency. It is to execute laws that have to have a prior and antecedent source, and that is the Congress or the treaties engaged in by Congress. And I'll just mention just some of the features that the framers, I think, thought that Congress would be a grave constraint on the president's power. And the concern was maximal with respect to military and foreign affairs. We often think today, oh, well, the president has to have more freedom in military and foreign affairs because that's where zeal and dispatch are needed. And how can you have a multi-member body that takes time for deliberation acting in military and foreign affairs? But in fact, the framers very much believed that Congress would play a role in constraining the president. It's from the pre-constitutional history. The Declaration of Rights by Parliament in 1689 wanted to end royal prerogative to maintain standing armies. It was to the raising or keeping of a standing army within the kingdom in time of peace is not allowed unless it be with the consent of Parliament. It is against the law unless it be with the consent of Parliament. And if you think, I don't know if you and your family read the Declaration of Independence aloud every July 4th, but it's a tradition I've tried to enforce with limited success. But one of the most stirring lines in the litany of grievances against the king is that he has kept among us in times of peace standing armies without consent of our legislatures. He has affected to render the military independent of and superior to the civil power. And in pre-constitutional practice, I think, reflected these principles, that the legislature must constrain the executive, even with respect to military and foreign affairs. The Continental Congress actively debated Washington's Articles of War, actively debated the terms of the 1779 peace, actively debated the terms of the treaty with Spain. Nobody thought that the Congress was incapacitated just because it was a multi-member body from being actively engaged in reviewing and ratifying or criticizing the president's decisions. All right, so you might say, great, that sounds good. Congress will constrain the president. But what the framers didn't imagine and had no expectation of is that we would have the party system we have today. And the party system, I think, has radically undercut the capacity of Congress to constrain the president because the fidelity to one's party will trump the fidelity to one's branch. Congress will act more as two fighting coalitions of partisan blocs whose loyalty will run to their president or whose electoral concerns in relation to an opposing president will constrain their actions. And Congress, I think, because of the unanticipated power of parties, we were to have separation of powers, not separation of parties, has undercut the ability of Congress to constrain the president. And I think the behavior of Congress in the wake of 9/11 has illustrated the point. Congress has not stood up to the president meaningfully in any respect. with respect to exercises of discretion in the war on terror. It debated, if you can call it that, the initial USA Patriot Act in a matter of days, an act making substantial changes in the powers of surveillance and other powers over domestic conduct of the war on terror. It eventually ratified, after the Supreme Court struck it down, President George W. Bush's improvisation of new forms of military tribunals. The court later struck that down too, saying Congress had violated the habeas corpus clause, the suspension of the writ clause, by in effect suspending the writ of habeas corpus where it was applicable and not providing a substitute for it. But Congress has, with respect to tribunals, with respect to the USA Patriot Act and its reauthorization, has not meaningfully done one thing to try to embody the framers' vision that the executive should be subordinate to legislation, that legislation should be superior to discretion. So that really takes us to the courts. And I think one of the most remarkable stories of the last decade in constitutional law and appellate advocacy has been the systematic way in which the courts, and in particular, Republican appointees on courts as the deciding votes. So this is not a matter of just a partisan thing. The courts as institutions have constrained the president in a remarkable series of decisions. The decision that the improvisations in the detention system at Guantanamo either exceeded due process, as the court said in the Hamdi case, or that military tribunals were not authorized by the Geneva Conventions or any other law. There were a number of justices in these cases that thought the authorization for the use of military force, which authorized the war in Afghanistan, did not extend to the homeland. You know, there's that great line in the steel seizure case where one of the concurring opinions says, just because the president is the commander-in-chief of the military does not make him the commander-in-chief of the economy. And similarly, you might say, just because the president is the commander-in-chief of the military, he is not the commander-in-chief of all domestic law enforcement systems by which we gather information in the criminal system. With respect to all of these issues to do with detention and tribunals, the Supreme Court has systematically, in a series of narrowly decided decisions, said no to assertions of executive power, and even said no to assertions of congressional power to authorize executive power that the court said was beyond the protections of rights in the Constitution. Now that is a remarkable story. It's a remarkable story because there are many countries in which the courts wouldn't ever be able to stand up to the executive at all, because the courts are thought of as thinly veiled rubber stamps for the executive power. So it's a remarkable story of judicial independence, and it's a remarkable story in that there was obedience to these decrees. You know, the great Justice Stevens, who retired this year, once said at a conference I was privileged to be at that when asked, what do other judges of other nations admire most about our courts? And he said, it's the ability to have our decrees obeyed, right? And which is not taken for granted in many systems. So the remarkable story is that the courts stepped in to play a role that, in fact, the Congress was intended to play, but probably cannot under the modern system of divided partisan government, because the Congress will always, especially with our frequent elections, will always defer to the president. It's never good politics, especially near an election, to do anything that seems to endanger national security. So the courts have played this powerful role. Last point, then I'll defer back to our moderator. I don't mean to overstate the case. There have been limits to the ability of the courts to constrain what I think has been an excess of executive zeal here. And in particular, the courts have been powerless to stop expansions of invisible domestic surveillance practices, in large part because of the assertion of a kind of executive privilege called the state secret privilege. That's one in which the courts have not really gone very far to try to reach the approach that President Starr referred to earlier, an approach of disclosure and transparency. You might say that corporate executives are free to engage in business judgment and do lots of things that shouldn't be called ultra vires, but the disclosure rules for publicly traded corporations force a lot of information out into the public about the bases on which those executive discretionary decisions have been made. And what is missing from the system, if we do think the executive ought to have all this managerial freedom, is that kind of disclosure and transparency, and the courts have not forced that issue. So that's one place where I would say they haven't gone far enough. But in a nutshell, I'm eager to hear later from my fellow panelists, and I know Professor Yu has advanced a notion of the modern presidency that I think is quite at odds with the framers, So I just want to say here that I'm much more originalist on this point than John Yoo. With that, I'll turn it back to
I will
Walter.
never live that down.
As a segue, Kathleen takes a position which I think to some extent is compatible with John's position that I would call the "it was ever thus." Presidents have always, made these claims. So I'd like to put to John and then to David Cole the question of whether there was an extravagance of claims of executive power during the presidency of George W. Bush that was not coextensive with what had come before. And represented a more radical shift. I mean, I think everyone agrees that a president has the authority to disobey some laws passed by Congress, not fanciful laws, real laws. Because otherwise, with respect to some kinds of laws, they would be unconstitutional laws in place forever. If Congress says the president may not fire a cabinet officer, or in the case of Myers, a postmaster, without the consent of the Senate, and the president complies with that, it'll never be tested. There's no way a case ever gets to court. So it's only by, if that's the case, that the lame duck Congress could say that all of Obama's cabinet members shall now serve for the next 10-year terms. And I think any subsequent president should consider that unconstitutional, as I do the 10-year term if you treat it as the minimum for the FBI director. But that's only by disobeying does the president even get a judicial test. But I think we've too often cited cases like Lincoln. The suspension of habeas corpus is provided for by the Constitution. It shall not be suspended unless in cases of rebellion or invasion the public safety may require it. This was clearly such a case. The issue was it doesn't say who shall suspend it,
but
right?
It's in Article 1.
I understand, but you could still, it is still silent on the question. But what is clear about Lincoln's assertion of power is that he did it publicly. There was no secret violation of federal law. And he was ready and willing for Congress to revise it and acknowledge the power of Congress. Indeed, Congress cut back on the procedures for suspending habeas corpus, and Lincoln unhesitatingly complied with the congressional limitations on the power. So that I think it's important to distinguish, as I turn this over to John and then to David, between inherent power in the sense that I think a president has a lot of, which is the power to act when the only claim against his acting is that it would be ultra vires. There's no law on the subject at all. Presidents can engage in lots of things. And a very different meaning of inherent power, which is the authority to resist an act of Congress once Congress has decided that it places a limitation. And so by some accounts, including mine, the refusal to comply with the Foreign Intelligence Surveillance Act, for example, and acts of Congress restricting torture were a violation done in secret without justification. But we've got people here who are fully able to debate that, so I will turn first to John Yoo and then to David Cole on that.
Well, thank you very much, Walter. I'd like to thank Judge Callahan for inviting me to appear. She didn't tell you, but the last time she asked me to appear on a panel, I couldn't make it because I was detained at the airport. And this was even before the TSA had all the machines to see what I had on my body. So I'm glad to be able to make it. I'm also, I hope you'll bear with me, I have a little trepidation speaking before an audience full of appellate judges and lawyers. Unlike my colleagues, I don't actually appear in court. I hope never to appear in court. And so when I was telling my wife I was going to be speaking before 300-some judges and appellate lawyers, I said, my God, you'd have to pay me to step foot before judges. And then I realized that's what all these guys do too. So I thank you very much for the invitation to speak. But I just want to make clear, I'm not an appellate arguer. I'm not very good at it. I'm just going to try to be very direct, if that's allowed. So,
allowed and encouraged even.
So So the first point I'd just like to make is I've learned in many years of my life never to disagree with Kathleen Sullivan. So Kathleen is right. She is the better originalist than I am, and I'm happy to testify to that effect before Congress whenever she comes up for confirmation. I guess am the admirer of the living Constitution, and in that respect, what I think has happened here with the presidency is that the framers established certain principles about executive power and then really thought that circumstances and the Constitution would interact. And Tocqueville said it first. He said the Constitution created what looks like on paper a weak presidency, but as America grows in its position in the world and it gets involved in wars and they come to have an empire, which he thought was a good thing, the presidency's powers would grow too, because that was the branch of the Constitution that was, in a way, designed to meet those circumstances. And so the one thing is, if Kathleen were right, why should we even have a presidency? Why not just let Congress create the agencies it needs to carry out its functions? I think the framers did reject that idea. The reason we have an executive branch, the reason the framers created a presidency, which was quite an innovation at the time, was so that there would always be a branch of the government in existence which could react quickly and swiftly to unforeseen circumstances. They realized, they said this in the Federalist Papers, Congress and legislatures can't anticipate the future. So you need to have some branch of the government that can respond to immediate circumstance. And the example they give in the Federalist Papers is war. Alexander Hamilton says in Federalist number 70, I believe it was, that the one best example of where you need one person in office at the time something happens to act immediately is what he called the management of war. And that was an example that they gave at the time of the framing, that you would need a president who could act independently of Congress. Now, this isn't supposed to be the way things work all the time. Obviously, the framers, I quite agree with Kathleen, the framers thought that Congress would be the dominant branch, and most of the time, the president would be carrying out Congress's directives, except for emergencies and war. And I think that's why we have the presidency in the first place. Second point I would make, and this bears more directly on the point of the panel, the presidency is also an independent and coordinate branch. And because of that, the courts and Congress have no right to tell the president how to interpret the Constitution any more than the president has the right to tell the other branches how to interpret the Constitution. Or if you go back to Marbury versus Madison, right, I don't want to make anyone actually pull out their copy and look at it. I mean, I will tell you, Walter and Ken are flipping through their constitutions while each other is speaking, so I'm a little intimidated because I don't think I have my copy pull out like Justice Blackwood, all dog-eared. And although people think I have a secret codex attached to mine that has stuff that no one else does in their copy. In Marbury versus Madison, the Supreme Court says, right, we have the power of judicial review. It's not because they're a superior branch. It's not because they're a final decider. It's because they have to interpret the Constitution in the course of deciding cases between parties. It's a natural part of saying plaintiff wins or defendant wins. But under that same logic, the other two branches have to interpret the Constitution too when they do their jobs, right? When Congress passes a law, hopefully they think about the constitutionality of the law first and don't enact unconstitutional laws. When the president enforces the law, he or she has to figure out what that law means. And he shouldn't or she shouldn't enforce unconstitutional laws either. Right? The Constitution does say, as both Walter and Ken have pointed out, that the president is charged of faithfully executing the laws, just like in Marbury. Right? What if a Constitution and a statute tell you to do two different things? What does the president do? Just like the Supreme Court in Marbury, the president has to follow the Constitution first and not follow the unconstitutional law. Second point I'd like to make, this goes to Walter's direct point about the history of this. This is not some wild idea that the Bush administration came up with or that I in particular came up with. I have come up with lots of wild, unusual ideas, but this is not one of them. Presidents from the very beginning have followed this logic. So I'll point us to Thomas Jefferson. When Thomas Jefferson came into office, it was a crime under the Alien and Sedition Acts to criticize the government. John Adams loved this law, obviously. Thomas Jefferson came to office. He released from jail everyone who'd been prosecuted and convicted under that law, and he ordered the U.S. attorneys throughout the country to drop all prosecutions under the law. And when he was asked about an explanation, he said, right? The courts have upheld the law. They think it's constitutional, and they're entitled to do so in the cases that come before them. I think the law is unconstitutional, and I'm allowed to pursue that view when I perform my constitutional functions. I think a president has every right to refuse to carry out unconstitutional criminal legislation when he decides or she decides who to prosecute or not.
John, let me just interject to ask whether you think there's a fundamental difference between a president declining to enforce a law which places constraints on others and violating, as something that Jefferson did not do, violating a federal criminal statute that makes what the president is going to do a crime. Aren't those quite different situations? And what is there, how much stronger a test is there to be satisfied in the latter case?
I think it's a great question. I mean, the second example brings me as Lincoln. Lincoln actually then, unlike Jefferson, right, who was passive and refused to enforce unconstitutional laws, Lincoln then, at the beginning and during the Civil War, took actions where he actively did things which didn't just violate congressional statutes, but violated what arguably were the Supreme Court precedents of the day. It's not just all the things he did at the beginning of the war, like raising troops without congressional authorization, taking money out of the Treasury, launching the war in the South, suspending habeas corpus. Remember, Lincoln refused to release a Confederate spy in direct contravention of order by the Chief Justice of the United States at the beginning of the war. But think about what the Emancipation Proclamation was. In the Emancipation Proclamation, the President of the United States freed all the slaves in the South as part of his commander-in-chief power. Now, we're all lawyers. Anybody remember what the governing Supreme Court precedent on the constitutionality of slavery was in 1863? It was Dred Scott is still the law of the land in 1863. Chief Justice Taney is the author of Dred Scott. He's still the Chief Justice of the United States in 1863, right? In 1862 and 1863, Lincoln actually acts quite inconsistently with Supreme Court precedent when he freed the slaves. He did it solely under his executive authority. So I think that's a good example. Now, people have argued that Lincoln was a dictator. I think he was only acting under his powers as commander-in-chief during the war. Third example is more directly on point with Walter's question, is FDR in the years leading up to World War II. Right? Congress passed a series of neutrality acts. And let me add, I'm picking presidents on purpose. I'm only picking presidents that most people think are great presidents. So, I'm trying to convince you by showing that there's actually a tie between success in the office and a broad view of your powers, right? The neutrality acts before World War II made it illegal for the United States to assist any of the parties in the fighting, right? And these are famous cases to, Justice Department people, but President Roosevelt started sending airplanes, destroyers to Britain. Right? And he was asked, aren't you directly violating the neutrality acts? And he would say things like, those destroyers are so old, we just don't need them anymore. They're obsolete. He called them overaged destroyers. Like you go to the surplus at the Army Navy store and pick some up because the Navy doesn't need them anymore. Same thing he said about the airplanes. And then he ordered the Navy to start escorting convoys across the Atlantic and attacking German submarines, all without congressional permission, all in violation of the neutrality acts. And I would say in all these cases, I'm glad that Roosevelt, Lincoln, Jefferson did what they did. I think they did it in the best interest of the country. They didn't do it to grab power. They thought they had to because of circumstance. And it was better for the country that they did what they did. And I wish they'd done it earlier in all those circumstances. But let me take the last point then, which is the Bush administration and the policies of the last 10 years. And Kathleen raised the issues of the response of the courts and Congress. Again, I never disagree with Kathleen Sullivan. So I fully agree with her. Congress has, I think actually I'm the only person who's worked for Congress. I worked as an aide to Senator Hatch about 15 years ago now. And I think Congress does have ample constitutional authority to stop the president from doing anything he really wants to because it has the power of the purse. And I quite agree with her that what you have seen is that Congress just doesn't want to do it. When I was in the Congress, if we wanted to change some administration policy, it wasn't that hard to do it. It's really a question of political will, not constitutional power. And so I think with all these policies that the Bush administration pursued that have been mentioned, surveillance, interrogation, military commissions, habeas corpus detention, to me, this was exactly why the presidency was created. We had an attack on 9/11 that was unforeseen and unlike any war we've been in before. The president immediately reacts and responds because he's the person in office at the time. He's trying to figure out how to adapt our system to this new kind of war where we're not fighting a nation state, we're fighting a stateless terrorist organization. Congress can come in and turn around and stop any one of those policies if they want to, and they don't. As Kathleen pointed out, actually, Congress in the military commission's area in habeas actually tried to eventually support the president's authority, and the courts stepped in and struck that policy down. So the last thing I'll say is I don't think what we've seen is out of line with historical example when you compare it to other presidents during wartime. I think in the Bush administration, Bush tried to work with Congress, but the Constitution gives him the authority to act first, to act with initiative, and that the system does give Congress and the courts their shot at the issues immediately after the fact. And if you see a situation where people think, oh, the Bush administration went too far, or now the Obama administration is going too far, and they're raising these claims of unilateral authority, they are, but the Congress and the courts have ample authority to stop them if they want. And I think actually the consequences for the country have been better when those branches have worked with the president to make sure we have the most aggressive policies we can within the Constitution to fight the kind of threats we have before us now. Thank you very much.
David Cole has challenged executive power in cases that he has argued before the courts, and is likely to have a less sanguine view of the extreme deference to the law and to Congress exhibited by recent administrations. David?
Well, I can't say that I've learned never to disagree with John Yoo. But I guess I want to start by thanking Judge Callahan for that brilliant collective introduction of the panel, because I'm sure it wasn't lost on most of you that 90% of all those accomplishments in that collective introduction were judge, general, dean, president stars. The other 10% were the other members of the panel here. And I don't know why I'm here, but so I thought that was just brilliant on Judge Callahan's, and I'll always be indebted to her for that. I will agree with John in this respect that presidents, I think everybody on the panel would agree that presidents have often, particularly in moments of crisis, overreached, have taken matters into their own hands, have exercised authorities that might well have been questionable. But I think the difference is in how they do it. And Walter's sort of opening, or his interruption of John, raised that point, right? Which is there's a difference between doing something publicly and doing something secretly, and there's a difference between declining to enforce a law and acting in direct violation of that law yourself. And I think what we see when you look at the last 10 years is that the notion that there is a tie between, as John put it, success in office and broad visions of executive power has some counterexamples. One of them is President Bush. Another is, I think, his immediate predecessor in the similar broad scope of his own executive power, and that is President Nixon, who, as many people here will remember, in his famous interview with David Frost after leaving office, Frost asked him, why did you think you had the power to engage in warrantless wiretapping during the Vietnam War? And President Nixon said, in my view, if the president does it, that means it's not illegal. And of course, President Nixon learned the hard way that that is not our theory of constitutional separation of powers. But President Bush, and in large measure with the assistance of John, resurrected that principle with one caveat. So it's not if the president does it, that means it's not illegal. It's if the vice president does it. That means no, it's not. It's if the president does it and says it's pursuant to his commander-in-chief authority, it's not illegal. And in that respect, I think the Bush administration's assertions of executive power to disregard and contravene law are really quite unprecedented. They asserted not just an inherent power to take initiative in an emergency situation, as President Lincoln did, and then go to Congress and say, look, here's what I'm doing. I had to do it because you weren't in office. I mean, you weren't in session, and the troops were coming up from Baltimore. I had to take action, so I suspended habeas corpus. But if you think it was wrong to do, tell me it was wrong. That's not what they did. Instead, in secret, they wrote opinions which said that the president can blatantly violate laws that are directly restrictive of his actions. And they did so in two contexts in particular: the prohibition on torture, in the memo that John wrote and Jay Bybee signed off on. They concluded that torture is something that I don't think anyone else ever thought torture was limited to. But then they said, even if what is being done is clearly falls within the terms of the torture statute, the federal torture statute, that statute cannot be applied to the president. Why? Because the president, as commander-in-chief, cannot be checked by either branch of government when it comes to engaging the enemy. And so if he decides that to engage the enemy, we need to torture the enemy, that's his prerogative, and no one can stop him. And John, in prior debates, has said if the president decided to crush the testicles of a suspect's child, that would be perfectly within his constitutional authority. And he told the Office of Professional Responsibility.
That's not true.
And if he told the Office of Professional Responsibility that if the president ordered the extermination of a village, that would be within his executive authority. That's the kind of assertions of power that we saw. I think a real failure to live up to what Judge Dean General President Starr suggested was the responsibility of lawyers in the Justice Department, which is to say no when you should say no. The same argument was made with respect to warrantless wiretapping. We have a statute on the books, the Foreign Intelligence Surveillance Act, that makes it a crime to engage in wiretapping without a warrant, expressly contemplates a limited exception for wartime, 15 days, but then you have to come to Congress and get further authority. And the president took the position, I can engage in warrantless wiretapping in contravention of that because it's engaging the enemy. Similar argument was made, not in secret but publicly at least, to the court, to the Supreme Court, when it came to review of the detention of enemy combatants. The government argued in the first case, Razul, that it would raise serious constitutional questions if the court were to interpret the habeas statute to extend to Guantanamo, because then you'd have Congress and the courts checking the president with respect to engaging the enemy in wartime. And they can't check the president when it comes to engaging the enemy in wartime. All 9 justices of the Supreme Court rejected that position. In the Hamdi case, they took the position that the courts could not assess the factual validity of the government's claim that the person was an enemy combatant. Justice O'Connor said, we certainly can, and indeed we must, under the Constitution. So I think we saw under the prior administration assertions of executive authority that really go far beyond the kinds of examples that we've seen from history. And I think the lesson of history, unlike the lesson of history with respect to Lincoln or FDR, the lesson of history will be that these were grave mistakes, that these were failures of vision, and that this is precisely why it's critical to have a system of separation of powers with checks and balances that does not permit one man to engage in uncheckable executive power.
John, I'll let you respond.
Thanks. Sorry for interrupting.
No, that's fine.
But
I interrupted you. So.
David brings it out of me. I try to restrain myself. I just want to make three quick points. First, I actually don't think that the president has a power to act outside the Constitution. I think that the commander-in-chief authority is a broad power. It's only triggered during wartime. And I think the problem Nixon had is he tried to claim these are very broad authorities to combat an internal security threat that was non-existent. And I think that's a big difference between Nixon and a lot of other presidents and with President Bush. I think it's undeniable that we were attacked on 9/11 by a foreign enemy. I don't think President Bush, unlike President Nixon, made up some kind of crisis in order to expand his presidential powers to pursue his domestic opponents. I don't think President Obama is doing the same thing, despite what some people, critics on the right, might think. I think President Obama is still a commander-in-chief, and we are fighting wars in two places, in the war against terrorism, and he's also using his constitutional authorities to do things like, in fact, more so than the Bush administration did, like in the area of using Predator drones to try to assassinate members of the enemy. The second thing is I think that it cannot be the case that Congress has the full authority to tell the president to do whatever it wants. Could Congress, for example, pass a law? I think Walter actually referred to something like this. Could Congress pass a law that made it a crime for the president to order his generals in the field what to do and not to do? I mean, is that consistent with the Constitution? There has to be some core of presidential power that Congress is not allowed to take away. And I think even cases like Youngstown reflect that and talk about it directly and point. Can Congress pass laws ordering the troops? And actually, the example I'm giving you is the one that actually triggered the impeachment crisis with Andrew Johnson, because that's what Congress did. Congress basically said the president could not direct his generals in the field in the occupied South on how to conduct reconstruction. Right? And I actually think the system worked. When the president did, if Congress didn't like it, they tried to impeach him. They almost removed him by office by one vote. The second thing I say is that things like FISA and the torture statute, I think the point there is that those laws were not written with this kind of war in mind. And yes, the president could have gone to Congress and gotten new laws written. There's a cost in this kind of war because you have to reveal a lot of information in public that could destroy the very advantages that you had in this kind of covert conflict. And so what the president tried to do is update those laws for this war and then tried to tell Congress what they were doing in secret sessions. Obviously, that didn't work very well. But that was an effort to try to adapt to this kind of secret war we have. And the last thing is, I think all presidents are fully, happy to be judged on the consequences. And it's easy to say now. One might think, well, history will judge Bush badly, or it could judge Obama badly. It's going to take 20 or 25 years to tell, right? But I think the presidents have to act in the circumstances. I don't think that Bush overreacted to the kind of challenge we had, but I don't think the Constitution is going to give you that answer, or the law is going to give you that answer. I mean, if you want to make it one based on whether it was worth it, then we're going to have to wait and see. My particular view is that it was. I think the administration stopped terrorist attacks from occurring in the country, and the Obama administration has continued with that success. But I think that's perfectly fine if you want to judge it on those grounds.
Let me see if I can have you explicate a bit how this is supposed to work. In your opening remarks, you said that Congress ultimately has the authority to control the president. If you take a matter like foreign intelligence surveillance, presidents going back in the 1950s, probably the 1940s on, assumed that they had inherent authority to order electronic surveillance to gather foreign intelligence when it was not to be used for criminal law enforcement purposes, when was not the object. The U.S. Supreme Court, as we moved from the 60s to the beginning of the 70s, rejected that proposition and said that you are not exempted from the Fourth Amendment because you're labeling it foreign intelligence surveillance. Congress then passed the Foreign Intelligence Surveillance Law, the purpose of which was to authorize foreign intelligence surveillance, to allow foreign intelligence surveillance. But when you put that machinery in the hands of the executive branch, Congress thought, it's critically important to make sure that it's not misused. We'll have a special court of 3 judges who will meet in an intensely secure facility from which there has never been a leak, who will be asked to authorize and to memorialize the basis on which a foreign intelligence surveillance tap is actually conducted. That's why you don't wind up tapping Al Gore or John Kerry. It may be that they approved 100% of the applications after the Attorney General and the FBI had agreed to put them forward, but that's because that was a great restraint. You had to go before 3 Article 3 judges and make this submission, which is kept a part of the secret permanent record. So Congress had done, and Congress said, if this don't work, you can take 72 hours. If it's not practicable to do it sooner, I think a president that needed 2 weeks instead of 72 hours could have been told that he didn't have to constitutionally comply with that in a time of great emergency. But ultimately, you have to comply when it's not utterly impractical to do so. Presidents have to comply. And yet what happened was the president didn't comply and didn't tell anybody he wasn't complying. So you secretly engage in wiretap, violating the procedure set up by Congress. Now, and it's only because of a leak that any of us know that. So what I don't understand is how this notion of congressional control is supposed to work when a president secretly declines to comply with the law. And this is a question really about how is Congress thought it had exercised its oversight?
Well, look, first I think the president has constitutional authority over battlefield intelligence and surveillance. And this question is, well, now that we have this kind of war where enemies are infiltrating into the country, how far does that power go? When does it become law enforcement, which I think of as the FISA system? On the other hand, the 9/11 attacks caused a huge problem for that system. As you described, Walter accurately described exactly how the system works. The problem is, though, that you need already to have a target in mind, right? Under the FISA statute, it's written very much in the law enforcement mold. You have to have reasonable reasons to think someone's already a likely terrorist or enemy before you can get one of these secret wiretaps. That, unfortunately, is not the problem that the 9/11 attacks thrust on us. We didn't know we don't have a list of the suspected members of Al-Qaeda the way we have a list of the suspected people who work in the Soviet embassy, right? If you wanted to surveil all the emails that went from Afghanistan to the United States on September 12th, you could not do that under FISA because you didn't have a specific identity. So this is what the president did. I think it's quite, I think he had to make a choice. He could have said, we're going to stick with the FISA system, and our ability to get intelligence is going to be very limited. Or we're going to do things like try to intercept all the emails coming from Afghanistan to the United States the next day without a specific target. Now, Walter's right. The administration has to do that in secret, right? If you announce to the world we need new law to allow us to wiretap email streams from Afghanistan into the United States or the Pakistan frontier now into the United States, right? Well, they would have stopped using the email system within 24 hours. So what the administration did, I think, was try to figure out a way to have oversight and cooperation, but in secret. So the administration did brief the leading members of Congress about this, what they eventually called the terrorist surveillance program, right? And asked if there was objection. If any one of those leaders had said, you're not going to do this, I assure you the administration would have stopped, because the last thing they wanted in the months after 9/11 was to have a conflict between the president and Congress in the, right after we'd been attacked. So I agree, well, there's no sort of set obvious way to conduct oversight in public when you're conducting a war where a lot of the actions and the intelligence are covert. But that doesn't mean that they can't do it in informal ways, right? And I think that's what, if members of Congress then didn't like it, before or after the leaks, they could have cut off funding for this program, and the NSA would have stopped it the next day. They never did. In fact, as far as I can tell, Congress, right, eventually authorized the program and has continued to fund it. It seems to me in the same robust nature that had been going on under Bush. I think the system did work, though.
I think we've moved, if I briefly comment, in this sort of endless war, the indeterminacy of the war, into an era where we're really grappling for a scaffolding, a legal and constitutional scaffolding. But I think what John just said suggests that there is a very wide sense of agreement that there needs to be some form of consultation with the Article 1 branch. There needs to be some engagement in order to achieve that which is very important at the founding, that is the idea of balanced government. We do not want an imbalanced government, an overweening executive or an imperial Article 1 branch. Madison warned about the dangers of the Article 1 branch or the legislative branch, and we need to build in structures such as bicameralism and protecting the presidency through the veto power and so forth. I think that the problem may have been over these last 10 years, one of a perception that I think endures to those of us who are not privy to all that John and those involved in the litigation are aware of, and that is the appearance of executive unilateralism. That has been, I think, the principal complaint laid at the feet of the administration. And one might say, well, where was Congress? And Kathleen has very well articulated the case that there may simply be institutional limitations by virtue of the partisan nature, the emergence of political parties, and so forth. I would say 2 cheers, though, for Congress, because as a young pup on Capitol Hill, working, however, only part-time on Capitol Hill, during the days of Vietnam, I heard J. William Fulbright. I heard the presidents on party stand up against Vietnam. I saw Eugene McCarthy make the decision or announce the decision to, in fact, challenge a president of his own party, really all about the war. So it obviously will come down to a position and to a situation of leadership and the sense of, how important is this issue and how much do we disagree? But one of the untold stories, I think, of the last 10 years is that the Congress did not disagree openly, overtly enough to prevent what is now seen in retrospect as executive unilateralism.
Any comments, Kathleen, and then
Sure.
David?
Well, I agree completely with Ken Starr and John's earlier comment that it's a matter of political will, not constitutional constraint, what Congress might do. And perhaps the events of the most recent election may destabilize some of the patterns of incumbency and entrenchment that lead to these Congress's more supine behavior in the last 10 years. I would just like to go back to the commander-in-chief point for a moment and just disagree a bit with my friend John on the scope of that clause. I think in trying to root the argument in the original Constitution rather than the living Constitution, we don't want to overread the commander-in-chief clause. It's often misstated as the president shall have the power of the commander-in-chief, as if it's a delegation of power. All it actually says is the president shall be the commander-in-chief. And the implication is he's the commander-in-chief as an agent of the Congress. The original framers' concern was with standing armies and making sure that they didn't run roughshod over the civilian populace. And you wanted to make sure somebody was in charge of them. So I don't think we should overread the commander-in-chief clause as a legitimate source of these broader claims, especially not when applied, this would be my second answer to John, to a conception of the battlefield that encompasses not just indeterminacy in time, an indefinite war into the future, but indeterminacy in space, no geographical or spatial boundaries, including the homeland. I think if you want to have a living Constitution conception of the commander-in-chief, if it's applied to formal hostilities that are governed by the laws of war, that's one thing, because there's a set of international treaties and conventions that constrain the president's power as commander-in-chief in that arena. But if you use the commander-in-chief power to justify surveillance in the homeland, because you say that that's in effect the battlefield, then I think we lose all distinction between the realm of war on the one hand and the realm of law enforcement on the other. And I think one of the reasons why the court was able to stand up to the claims of executive power in the series of cases from Hamdi through Boumediene was that the claims of the need for urgency seemed overstated. The great line in Ex parte Milligan, which is the 1866 decision that said that it was not permissible to have a military tribunal for a Yellow Dog Ohioan who was suspected of acts of criminality during the Civil War. The reason why you can't put him to a military tribunal is the civilian courts were open, and there was no need for martial law in Ohio. And therefore, you could have allowed the law enforcement system to proceed. And I think there's a bit of that Milligan assumption that the court may have had here. You can't tell us you needed to improvise modes of detention and military commissions that weren't authorized by law, when the time is ticked on, 1 year, 2 years, 3 years, 4 years, 7 years, 7 years after the events of 9/11, you can no longer say that these were necessary responses to emergency. The civilian courts were open. So I just wanted to push back a little bit on the overreading of the Commander-in-Chief Clause and its extension to the homeland so long as the civilian courts are open, and law enforcement and civilian courts can take care of a lot of the worst problems, as we've seen with some of the most recent episodes of attempted terrorist activity that have been tried in civilian courts. And just one last point, the most articulate spokespeople, I think, in questioning the military tribunal system were not civil libertarian lawyers. It was the men and women of the JAG Corps and the military brass whose fidelity to the Geneva Conventions and to the laws of war and to the procedures of military justice in the UCMJ, I think, steeled them to a sense that it's important to follow procedures both within the military system and the dividing line between that system and others. And I think it's no accident that Justice Stevens, who wrote pivotal opinions in the war on terror cases and certainly provided the pivotal vote in some of them, was the only living member of the court who had served with great distinction in the Navy in World War II, and I think came from that tradition of military respect for the rule of law that drove those decisions. So I don't think the Commander-in-Chief Clause can do quite all the work that John's attributed to it, especially not if we extend the notion of the battlefield to the homeland.
David? Just on that question of the Commander-in-Chief Clause, there's a tremendous article by David Barron and Marty Lederman, who were recently, both in the Office of Legal Counsel before the Bush administration and were recently there on the Commander-in-Chief Clause, looking at the history of the Commander-in-Chief Clause and concluding that the history, in fact, quite contrary to what John suggests, has shown that Congress has in very great detail regulated and restricted the way in which the president conducts wars. They say where you can fight, where you can't fight, where you can bomb, where you can't bomb, what tactics you can use, what tactics you can't. You can't torture, for example. They say that, and they've been saying things along those lines for our entire history. But I wanted to talk about just tell one story about the problems with secrecy and this kind of checking function of whether the check comes from the courts, as Kathleen has talked about, or from Congress, which is rare but sometimes happens, or from the public, which also happens. That check can be deviously undermined. And here's an example, and this postdates John's leaving the office. This is the Office of Legal Counsel, I think, that should be held responsible, but it's not John, it's his successors in the office. So when the memo that John wrote authorizing waterboarding and the like became public, as soon as it became public, it was unacceptable, right? And they had to rescind it. They rescinded it immediately and started working on something to substitute for it. They substituted something for it in 2004, a public memo. But at the same time, they wrote a secret memo that said, you can continue to do CIA, you can continue to do all of the things that we told you could do in the rescinded memo that John wrote. Then it came out that they had interpreted the prohibition on cruel, inhuman, and degrading treatment not to apply at all when we interrogate foreign suspects abroad. Because it's hard, whether waterboarding is torture, maybe you can make an argument about that. You can't make an argument that waterboarding is not cruel, inhuman, or degrading, or keeping someone awake for 11 hours, or making him stand in painful stress positions for hours on end, or slapping him in the face and the stomach, or slamming him against the wall. You can't argue that's not cruel, inhuman, or degrading. So what did they say? Again, in secret, just doesn't apply to foreigners. This is a human rights provision in a treaty that we helped draft and we signed, and we said, well, it doesn't apply to foreigners. In secret. When that became public, this is the one counterexample to Kathleen's story about Congress. Congress did check. John McCain led the charge, and almost unanimously, Congress said that prohibition applies to every human being, wherever they are held, wherever they are. It's a human rights treaty. It's not a Citizens Protection Act. And so what did the Office of Legal Counsel do? They wrote another memo saying, well, now we have to apply this cruel, inhuman, and degrading treatment provision because Congress has said we do. But you know what? None of these provisions are cruel, inhuman, or degrading either. None of these tactics are cruel or inhuman, and not even in combination. So if you keep someone up for 11 hours, slam them repeatedly against the wall, waterboard them 183 times, that's not cruel, inhuman, or degrading. And at the end of that opinion, they said, you know, we can't guarantee you that a court would agree with us on this. But don't worry, it won't go to court. Then, a year later, the Supreme Court in the Hamdan case said the Geneva Conventions apply to how we treat al-Qaeda detainees. And Common Article 3 imposes an even lower standard or a higher standard, I guess, of how you have to treat detainees in wartime. And they had previously said, well, we don't have to worry about that because it doesn't apply. Now the Supreme Court says it applies, so what do? They write another memo in 2007, again in secret, saying, well, now we've looked at it, you know, and none of these tactics are even inhuman or inhumane or in violation of the way that countries are obligated to treat our own people. And so in other words, they were saying in secret that it would be perfectly legal for another country engaged in a war with us to take our servicemen and subject them to all those tactics. Perfectly legal. When Matt Lauer asked President Bush that question on the Today or the Tomorrow show or the Evening show, whatever that show was, when he asked him that, President Bush wouldn't answer that question because he knew he couldn't answer that question. But of course it would be unacceptable if it was done to our people. It should be unacceptable if it's done to any human being. And the public lesson of what the law was, it was getting more and more restrictive, and we were making it clearer and clearer that human beings cannot be subjected to this kind of abusive treatment. And what did the Office of Legal Counsel do in secret? Write memo after memo after memo saying you can continue to do exactly what you're doing.
Small?
Yeah.
Yeah. All I would like to point out is that I don't see a failure in the checks and balances between the President and Congress. Congress, I think, was fully aware of the interrogation methods that were used and continue to be throughout this period. They may not be aware of the legal justifications that the executive branch might have for them, but Congress has its own ability to make its own judgments about whether what's happening in the war on terrorism is constitutional or not. And they can enforce it through their decisions on funding and the creation of the military and intelligence agencies. But they have to be fully briefed before the CIA can conduct any kind of covert action. The second thing is, Congress did restrict the military's ability to conduct interrogations. It's quite right. They did not pass a law applying those same provisions to the CIA. Right? I think Congress is playing an interesting political game where they want to take some responsibility to some areas, but they want to leave the intelligence agencies in the war on terrorism quite a free hand. And I think the reason they're doing that is because if you look at the opinion polls, the ones I looked at show 65 to 75% approval for aggressive interrogation methods of al-Qaeda leaders. And people may not like that or not, but I think that's why Congress is doing what it's doing. That's why it doesn't actually get into the nitty-gritty. They could pass a code on this issue, and they have not. They'd rather, and I think this is what's really going on, they'd rather have the executive branch go first and take the responsibility, and if things turn out badly or the public, there's a lot of bad publicity, then they just blame the president for it.
Well, what troubles me, and I direct this both to Congress and the president, is when something is done in secret, but it is said subsequently that 8 members of Congress were fully briefed. And those 8 members of Congress, rightly or wrongly, say, no, we weren't. They're lying. We weren't told. Yes, you were. I think shows whatever the truth of that is. Either way, it shows to me an utter failure when you have a public law where we've taken a position on something like that. In a democracy, we're supposed to be based upon the consent of the governed, not the consent of 8 members of Congress. That seems to me to be fundamentally to undercut the, so I'm not as sanguine as others are about the fact that, quote, Congress was told or 8 members were told, when if that's the public view, we ought to say we're going to amend the torture statute or we're going to amend the Foreign Intelligence Surveillance Act. And if we can't be specific about what we're authorizing, saying we're authorizing the president to engage in unspecified methods of data retrieval for the duration of whatever. But let's publicly say that's what that's what we're doing. Now, let me throw another log on the fire, because particularly turning the corner to appellate judges and those who appear before them, we've been talking about when we stay out of court by saying we're just not going to comply with the law. What you don't know won't hurt you, judges. Just go about your business, do those slip and fall cases. We'll let you know when we need you. To talk about those instances where the president is a constitutional actor before the courts. And how does the president's role and those of his law officers as Attorney General or Solicitor General, how does that role differ from private counsel or others? And when may the president assert his own view? Let me put a particular example as a log on the fire. One which never finally came to fruition, but was, I think, the single hardest question that I faced as head of the Office of Legal Counsel, and that was in 1995, when Congress passed, sometime after midnight, a floor amendment to the Emergency Defense Authorization Act that provided that every member of the military who was HIV positive would have to be discharged within 60 days from military service. The bill passed in that form. Congress adjourned. The president was going to sign the Emergency Defense Appropriation Act. That was a given as far as the lawyers were concerned. This act was a problem. Not only did groups that HIV support groups oppose discharging members within 60 days, there was what to me was surprising unanimity of opposition to it, to this provision by the military, that thought that it was affirmatively harmful. And so the White House wanted the Justice Department, was hoping the Justice Department would simply say it's unconstitutional. You don't have to comply with it. And the president could then sign the bill knowing that this provision would not be a problem. And after a great struggle, I had to go to the White House and say we did not believe that we could say that it was unconstitutional in the sense that we believed that the court would agree with us that it was unconstitutional if it went to court. And that was the standard that we had set in an earlier memorandum we had done for the White House counsel, that the president could disregard a law if he believed it was unconstitutional and in good faith believed that the court would agree with him, that was a necessary condition. And when acting on his belief that it was unconstitutional and he would not comply, would lead to a judicial review of the matter, as it did in U.S. versus Myers, by his refusing to comply and firing the postmaster, refusing to submit it to the Senate first, he got a judicial test. And we thought we could not say, given the deference that the Supreme Court had given to the political branches, to acts of Congress in the military area, we thought that Congress would, that the court would very likely uphold it. Say it upheld male-only selective service registration, for example, in deference to military. So we thought that the court, we couldn't say the court was likely to strike it down, and therefore we believed that the president had to comply with it. But the question then came, what would we do when a lawsuit was brought by a member who was discharged? How would we argue that it was constitutional, given the belief of the president and his senior military officers that it was harmful? I mean, normally, the simple rule of American constitutionalism is that the government may not make an imposition on your liberty unless that imposition advances some governmental purpose. It can't impose needless constraints on your liberty. And the purpose being advanced here was a more efficient military. Well, the military disagreed with that. That's what Congress thought. But General Saakashvili, who was chairman of the Joint Chiefs, and Admiral Perry, who was Secretary of Defense, believed that, A, we were going to lose critical people who were asymptomatic. The plaintiffs groups had already chosen their plaintiff, the world's leading Middle Eastern cartographer, whose critical skills, her critical skills were going to be lost to the military. But more fundamentally, General Saakashvili felt that we already had systems in place for people that had all kinds of symptoms for illnesses, a regular protocol, but that this was going to be, he said, we've sent these kids all over the world. They've gotten into trouble on shore leave. We've taken them from their homes and farms and cities around the country. He said, this is leaving your wounded behind. We do not leave our wounded behind. And he was deeply emotional about it. So a law that the president knows actually harms military preparedness can hardly be defended as a necessary imposition on liberty. So what we announced was that the president would in fact comply with it. And I'm not sure that was the right decision. We would comply with it, which meant that the first discharge would be processed. We knew it would be sued. But then we announced that the Justice Department, while nominally representing the Secretary of Defense and in court, would tell the court that we believed it's unconstitutional. We would not make a half-hearted defense. We would actually, and we would inform Congress that they might wish to secure the representation of counsel who would argue that it was constitutional. And that we submitted this to Congress. We were going to say our honest view is the president believes it's unconstitutional, and in his heart he knows it is, because in his belief it doesn't advance a legitimate government goal. What the court would have done would have been fascinating. Who does the court defer to when the president, drawing upon the advice of military leaders and whatever authority he has in his role or power or whatever as commander-in-chief, says that he thinks it's harmful? Who would the court defer to? It was going to be a wonderful test of deference. And our view was that the court doesn't owe the deference that a federal district judge does in an area that is within his responsibility. We didn't ever go to the mat on it because, having made the announcement, Congress repealed the statute rather than retaining counsel to do it. So that there are other examples. Ken, as Solicitor General, had instances where he declined to defend acts of Congress, one of which we later successfully defended. Right. And it comes up more recently in the context of Don't Ask, Don't Tell and the Defense of Marriage Act, which this president said he opposes, but nonetheless is complying with. Federal benefits are not being extended to same-sex spouses in states where their marriages are in fact lawfully recognized because of DOMA, and the president's complying with Don't Ask, Don't Tell. So he's made the decision to comply, and so far has been defending. What should the president do now that he's been more forthright about his position? And keep in mind, whatever your answer to that question is, what should President Palin, Solicitor General, do if the health care litigation comes to fore when they are in power and having to decide, whether to defend? One of the suggestions I would make is, in some ways it works better for the system if the president gives his honest belief. The president honestly believes that discharging 13,000 able-bodied men and women from the military is more harmful to national defense than keeping them. He therefore believes that Don't Ask, Don't Tell is unconstitutional. Why shouldn't he tell the court that? And why shouldn't the court appoint? This could be your first argument, John.
Actually, I think Kathleen will be President Palin's Solicitor General.
The Supreme
Court.
I
will.
The Supreme Court, but see, I would have President Obama's Solicitor General, were it to be Dean Sullivan, argue his honest view that it's unconstitutional, but have the court also hear from someone appointed as amicus curiae, Charles Cooper, whoever might want to step forward and argue full-heartedly in defense of the law.
Or Senate counsel and House counsel, right? There's a statute.
They actually have statutory counsel.
It says that in those situations, there's a mechanism for someone from.
So I mean, that's the issue. I do think let me throw one other log on the fire, and that is Governor Schwarzenegger and Attorney General Brown did not appeal the decision in California striking down the proposition that once again said opposite-sex marriage only in California. They didn't appeal. I think they were obligated to appeal, though they could have told the court, as I would suggest, that they believed it to be unconstitutional, but thought the appellate court should decide and not a single district judge. If they are so strong in their belief that it's unconstitutional, there shouldn't have been any litigation. They should have just ordered state authorities not not to comply with it and to issue marriage licenses to everyone. But if you're going to defend it in the district court, you ought to at least lodge an appeal and then let amicus counsel come in and defend it. I would have had the Attorney General file a strong brief saying that we believe that there's a constitutional right to same-sex marriage, but we're appealing a decision which we support in order to put it before you. But I open the floor up for consideration of what you ought to do when the president's view is contrary to the statute that his administration, state or federal, is defending. The floor is open.
It seems to me that the principal value or overarching consideration is, can we keep the process open for the separation of powers to work? And so, if you have a system in place where if the president and there is such a system, if a statute is declared unconstitutional and the president decides, I'm not going to appeal it, he's obligated to notify the Senate and the House, and then the Senate and the House have the power to direct their counsel to appeal the case essentially on behalf of Congress and to argue the case. And sometimes they do, sometimes they don't. But I mean, I've been in cases like that where the government decided we're not going to appeal this, notified the Senate, notified the House. They didn't care either, and so the case died. But it seems to me that as long as you have some process in place that doesn't give to the president the sort of final say in a way that is very difficult to check, and that's what I find most disturbing about the secrecy of the kind of process that I was talking about earlier. As long as you make the claim publicly, it seems to me that there's, so that the system of separation of powers can allow the dialogue to continue, I don't see it as problematic for the administration to say we disagree with this law, we think it's unconstitutional. I mean, I was involved in the flag burning cases where the Supreme Court struck down the Texas flag burning statute. Congress, every member of Congress stayed in overnight before the 4th of July weekend to say this is outrageous and we must pass a Flag Protection Act. Was it the Bush administration?
Yeah, David, I was on the opposite side of you on
exactly.
that.
But
remember your clients.
That's right. That's right. But that was an interesting case, right? Because you defended it, but in a very kind of tepid way.
I beg your pardon. Just because I was unsuccessful.
No, but not just because during the debates during the congressional debates over whether to pass, the president sent in his spokesperson who said it would be unconstitutional to pass a statute. And so then they passed the statute that the president had said would be unconstitutional. So it wasn't a real hard case for us to argue afterwards. We just cited the president's own lawyers. But Senate counsel and House counsel came in and defended it. And it was...
well, but we all depend... In fact, I think that makes David's point very neatly. The Office of Legal Counsel, through then Assistant Attorney General Barr, who was destined to become the Attorney General of the United States, testified for both houses of Congress that even if Congress did all of the things it was being guided to do by Professor Tribe and others, query whether Congress actually did that, the law would still be unconstitutional unless the Supreme Court changed its mind. Congress worked its will, and so this kind of poses then for us your problem, except it didn't quite intrude into the prerogatives of the presidency the way your situation did, Walter. And so it was our view that reasonable arguments could be made, I hope in a non-tepid way, on behalf of the constitutionality of the Flag Protection Act of 1989. And it really came down to Justice Harry Blackmun, because Texas versus Johnson, as you'll recall, was 5-4, that Texas's anti-desecration law was unconstitutional. Congress did, in fact, seek to take that into account and so forth. So we worked very collaboratively with a very able lawyer, Michael Davidson, who at the time was counsel to the Senate. And I think part of Michael's institutional role, we also dealt with the House counsel as well, but in the way that in its bicameral wisdom, Congress divided it up. It seemed that the wisdom and advice was really coming much more from the United States Senate, for whatever reason. That was a matter for Congress. So we worked very collaboratively, we being in the Solicitor General's office and working with the Office of Legal Counsel as well, to defend the constitutionality of the law, even though we had testified to Congress it's unconstitutional. The interesting question is then what happens when there is an intrusion by Congress or a perceived intrusion by the executive branch into its own prerogatives. Your situation really does raise that very, very neatly, because the Congress might the president might very well say, based upon the advice, just as on judgment, but here based upon the advice of military, the chair of the Joint Chiefs of Staff is saying this is affirmatively bad for the military, we're not going to defend it in court. We're just not going to defend it at all. We simply kick this back over to the Senate, to the House. They can then decide it. Those are very tough judgment calls. It does tug at the bedrock command to take care that the laws be faithfully executed, even if you disagree with the laws, or you think that the court will find the law unconstitutional. It is still the basic task of the executive branch to defend those laws and not to set itself up as it were, as a sort of judicial department. So Justice Byron White, final point just as a footnote, felt very strongly on that. And I remember this so vividly, his taking, I remember both as a law clerk, not Justice White, but Chief Justice Berger. But Justice White really took exception to what I think is a almost sacred practice of the Justice Department, which is to confess error. We believe, based upon our analysis, that this is typically, and not always in a criminal case, that this conviction cannot in fact stand. It should not have been brought, or based on the evidence, the conviction cannot stand, even though you've won at the Court of Appeals level. And Justice White believed strongly that that was a violation of the fundamental duty of the executive to take care that the laws be faithfully executed, and an intrusion into the Article 3 branch. You defend. We will decide whether, in fact, the conviction can properly be affirmed or not.
One small, David, but I think technical correction, which raises a larger point. I do not believe anybody but the United States can appeal. I don't believe Senate or House counsel can actually file an appeal or a cert petition. Notification is put forward if you're not going to defend the constitutionality of an act of Congress, but sometimes that's because you have prevailed below. The other side is appealing, so the case is already there, and they can come in and do counsel, but there's no authority on behalf of Senate or House counsel. Ex parte Lovett is a very good example of this, where in Ex parte Lovett, Congress, as part of its anti-subversion mania in the 50s, prohibited the payment of any government salary to 4 named individuals who were suspected of being sympathetic to forces of subversion. Those 4 individuals brought suit in the Court of Claims and won on the grounds that they were entitled to their governmental salaries, that this was an unconstitutional denial of due process and or bill of attainder to single them out in a legislative enactment. The Attorney General concluded, and the Solicitor General, that it was unconstitutional. But they complied with the law. That is, they didn't pay the money, even though they thought it was unconstitutional and the President had said so. I believe it was passed over the President's veto, in fact. They complied with it. They cut off their salary. The individuals won in the Court of Claims. I read the cert petition recently, thinking about this don't ask, don't tell issue. The Solicitor General filed a petition for certiorari saying, we actually agree with the decision below in the Court of Claims, holding that this is an unconstitutional provision. But at the request of Senate counsel, we are filing a cert petition and asking, and also because we think the final answer should come from this court, we will be telling you, even though we're seeking cert, that we believe the decision below is correct. And we suggest to the court that it allow counsel representing the House or Senate to appear as amicus and argue. All of that happened. The Solicitor General argued the statute was unconstitutional. The petitioners, the respondents, the individuals argued it was unconstitutional. Counsel for the Senate, appearing as amicus curiae, argued that it was constitutional. The court upheld the Court of Claims decision striking it down. That struck me as actually a very good process. And I want to bring California into the mix, but see if there are any comments first. The reason I think California comes into the mix is that the governor and the attorney general in California, when a federal district judge, as the shorthand saying goes, struck down Proposition 8, what the judge actually held is that there's a constitutional right to same-sex marriage, that it violates equal protection clause of the federal Constitution to deny a marriage license solely on the basis of the same sex of the partners. The governor and the attorney general did not appeal that decision. There were interveners who represented those who had supported a referendum that restored the ban on same-sex marriage in California, and they've attempted to intervene. They attempted to intervene. Intervention was actually denied by the judge after the fact. But they were allowed to present evidence. Chuck Cooper was counsel for these interveners who were defending the statute that the governor and the attorney general declined to support. The interveners have purported to appeal to the Ninth Circuit. I actually think that I think this case is over. This is a lawsuit brought, which really shows the difficulties of these issues. It's a lawsuit brought by somebody who wants a license. If I apply for a hunting license from the state of California and the hunting commission denies my hunting license, and I sue them and win in the trial court, and the state decides, all right, never mind, we're not going to appeal, here's your hunting license. Nobody else can come running in and saying, you know, I'm an animal lover, I don't want Walter to have a hunting license. It doesn't work that way.
Depends how accurate it
There are some circumstances.
Well, you can intervene, though, for purposes of mounting an appeal. You can be granted party status.
But I
under
don't.
Federal procedure.
But there is a provision, but not when you're a party without Article III standing. You can also come in. But if nobody who has a stake in the outcome is going to appeal, it's not there. Now, it's said, and the strongest argument is that referendum supporters, the whole idea of the referendum is to get around the existing officials and to defend the referendum. Well, the interveners did have a right to defend the referendum. There was a challenge to the validity. The sequence was this. California Supreme Court said there's a constitutional right to same-sex marriage under the state constitution. And then a referendum was passed to overturn that and restore California law to allow man and woman marriage only. That referendum was challenged on a whole multiplicity of grounds that it wasn't a valid referendum. Intervening supporters of the referendum were allowed properly to intervene and defend the validity of the referendum. And they won. And everybody agrees that the referendum is valid and it changed California law. This new lawsuit is a federal constitutional challenge. It accepts that the referendum was fully valid in changing California law. So now I don't see where there's a right to appeal.
Look, I actually think, I agree with you, and I think I agree with, I guess I'm at odds with the President Starr. I hate to do that, but I guess I am. I think that the governor and Jerry Brown were more than entitled under their constitutional authorities to not defend the statute if they thought it was a violation of the federal Constitution. I actually thought this is, I want to play against role. There were some things that the Bush administration actually did that I didn't agree with. And one of them was the McCain-Feingold Act, where the president signed the bill. He said in his signing statement, I think it's unconstitutional, I'm going to sign it anyway. And then he defended it in court, which actually seems to be the exact reverse. If you think the bill's unconstitutional, veto it, and then don't defend it and let other people defend it. And I think Governor Schwarzenegger and Attorney General Brown are more than entitled to do that too, unless the state constitution requires them somehow to do it. I don't know whether there's a difference between the California Constitution on this point and the federal one.
Can we go to a couple of quick questions? How many?
2 minutes.
Yeah.
3 minutes.
How many?
3 minutes.
What? Yes, questions. That's right. Questions. The microphones are open. Please step up to the microphone and ask. Fire away. Yes, sir.
I hesitate, but I have to correct Judge Starr on his history. Ken will remember that I was in the White House counsel's office in the Reagan administration. In fact, on the legislative veto, what happened was that went through the White House counsel's office, and the president was told, my God, Olson and Starr are right for once. Seriously did want to add a little perspective from a very small role in the White House. I don't think the other branches, I realize I'm surrounded by judges, many of whom before I argue, certainly from the executive branch perspective, other branches do not have the same level of accountability and responsibility for their actions. In terms of if something disastrous happens, the person who has the responsibility is the President of the United States. He is the only one who takes an oath that says, preserve, protect, and defend the Constitution. Every other federal officer is support and defend. Give an example that is not as controversial as what you guys have been talking about up here. There were government shutdowns in the Reagan administration. There was a government shutdown in the Clinton administration. People got blamed different ways, but both presidents, and I think every president in that situation, will actively disobey fundamental propositions having to do with Congress must appropriate money. And they will pay the military, and they will keep in place people whose functions they believe are vital to the protection of the country, and they will also keep the Social Security checks going. And I'm not aware that anybody's ever complained about that. To let judges in on a secret, it is just true that presidents, at least in my experience, quite nicely, do not think judges are going to get blamed if they do something that affects the security of the country. And it is very, very easy to discuss these things in the abstract and to discuss the various rights that may be involved and how the branches should all work together. But at the end of the day, there is one human being who is responsible for the safety of the country and preserving it, and that's the President of the United States. Lincoln said in the habeas corpus, must all laws fall down so that this one could be preserved. I think we are in the middle of something, and I invite panelists to respond, that is different from anything we've ever dealt with before. It doesn't fit into these boxes, but however we deal with it, if there's another 9/11, if there are the kinds of things that happen that maybe we learned because of some of the investigatory techniques that were used that otherwise might have happened, no one is going to blame the Supreme Court of the United States, at least not most of the public. They're not going to blame the Congress. It's all going to go to the President. I just tossed it out there.
Thank you. Any other questions? But no, or statements. We actually welcome. It was a useful commentary, and we welcome statements as well as questions. Criticisms are out of order. That being the case, let me just conclude by recalling my favorite moment at the Constitutional Convention, which
you were there?
Close to it.
He voted against it.
I taught the debates for 7 years with John Hope Franklin and William Luchtenberg. So I went through with a group of students numerous times the debates in the convention, and few moments are as precious as when Nathan Gorham asked his colleagues at one point, does anyone here imagine that 150 years hence, this vast continent will still be governed as a single nation? And not a single delegate rose to say they agreed that would be the case. And we've made that, and another half century or more beyond. And during that time, we settled the continent. We fought and lost hundreds of thousands, marshaled millions to end slavery. We combated the most serious depression the world has ever known. We managed to turn back the tide of fascism in Europe, to end the Jim Crow regime in the South, and to win the Cold War. That is no small list of achievements for any government established under any constitution. And so I think to that degree it has served us well, and we should let the dialogue continue. Thank you.
Beautiful. That's a great close.
Yeah.
John, always good to be with you. Thank you.